We look at the question 1, okay? CLP Supplementary Exam 2025. Okay, before you read this question, because this is a compulsory question, so all you need to do is you have to read the question, this one first. What is the requirement of the question? Then you read the long facts. This will be saving a bit of your time. Can you hear me? Can I? Can you hear me? Right recording. Okay, good. Okay, I will read the question. And okay, basically the question said like that. Okay, Rodi here actually borrow money from rich man to start a cafe. It's called a Rascals Cafe. And eventually this is like a loan agreement. So in that agreement, Rodi promised to pay Richmond for that 500,000 ringgit that he would have borrowed from Richmond to pay within 12 months. Okay, subsequently, what happened is that the Rascal Cafe um, have a very prosperous business. Okay, so Richmond subsequently said that, okay, I don't want you to pay the loan anymore. And instead, I want the shares in that particular business. But subsequently, what Rodi did was he discussed with his partner, you see, he discussed with Rascal, and then they declined Richmond's proposal, in which they said this Rowdy will still promise to pay the loan in according to the terms of the agreement, and they would not wish to transfer the shares of Rascal Cafe to Richmond. Okay. As the end result, what happened is next is that Richmond got very disappointed and very upset. So Richmond posts a defamatory video via his Instagram describing Rodi to be ungrateful, a thief refusing to return the money borrowed from him, and claimed that Rodi and Rascal used his money to operate cafe. Okay, and then on top of that, they both refuse to return any profits or share any profits with uh, Richmond here. Okay, so as a consequence of this Instagram posting, the business dropped and the cafe business actually began to make losses. So basically, from the first paragraph itself, we know that this is probably a loan agreement is the subject matter here. There's possible of a contractual issue, or the second issue is that there is a defamation that happened. So most likely, this case is a what we call a civil case here. Okay, you must remember the structure that you approach this question is very, very important, because burden of proof and standard of proof in evidence for criminal case and civil case are different. So your mindset must be very clear from the beginning. Okay. After that, Rodi and Rascal actually started a legal action against Richmond for defamation. Okay. And subsequently, Rodi and Rascal actually plan to adduce agreement at trial to show that the loan is actually not due. And Richmond's publication was with malice intent. That means he had bad faith to publish this Instagram video. But however, they are caught with some problem. Rowdy here is only having photocopy of the agreement. The original agreement is with Richmond's solicitor. Okay, make sure you understand this statement clearly, because when we want to tender a documentary evidence in court, the best evidence rule say that we must give the court, or at least show to the opponent or the judge the original version of the documents. Why is that so? If it is not this case, the opponent counsel will oppose on the ground that this document is forged and this document is not a genuine version. It is not authentic in nature. So you'll have this sort of evidentiary challenge. Okay, but now Rodi had only the photocopy of the agreement. Okay, so it's the photostat secondary agreement, a secondary document. So Rodi and Rascal intend also to produce the business account to show profits before the publication and also the after publication sale to show what? To show damage suffered by them after the defamation incident. Okay, so these accounts are, who is the maker? It is Abu. And Abu had now resigned from the company and traveling around the world. So Richman has since denied being the author of the video and said that his Instagram was hacked at the time of publication. So now our task is very simple. We must advise Rodi and Rascal, who are the plaintiff of this case, this defamation suit, based on Evidence Act itself. Okay? So the first question is that the admissibility of photocopy of that particular agreement. Okay. In order for you to admit one evidence in the court, there are three elements actually. Three elements. Number one, the agreement must be relevant. So, like I've told you before this recording has begun, it must fit in one of the criteria in Chapter 2 of Evidence Act. That is from Section 5 to Section 55. Okay, so this is the relevancy of that particular agreement. After passing the relevancy test, then we will consider the admissibility issue. Some evidence is actually relevant, but however, it is caught by the strict admissibility law, in which to say the judge has the discretion to reject this piece of evidence. Okay, after you have fulfilled these two, we will talk about the weight given to that particular evidence. Okay, because the justice system here works like the penimbang, timbang tara. Okay, if you put more evidence on your side, then the judge, whether like you in personal or not, will have to give favorable judgment based on the weight of the evidence you put. Okay, if I'm representing the plaintiff, if I manage to put a lot of evidence along the side which is relevant and supporting our case, we will win the case. As simple as that. Okay, now how you want to argue in your examination is such. The law is, number one, you have to argue a little bit about relevancy. Okay, evidence can only be admitted in two forms. That is, facts in issue. Okay, fact in issue or relevant facts. Okay, facts in issue here. If we talk about defamation case, defamation case, you have to explore what is the elements of this tortious action. Okay, we have three elements because we are quite used to do defamation in our firm. First is that the statement itself must be defamatory in nature. And second thing, there must be refer to the plaintiff or refer to the claimant. And the third element is it must be published. How to win this case is actually the facts in issue is actually the Instagram post itself. The Instagram post itself would have satisfied, you see, a thief, ungrateful. This is defamatory remark which will lower the reputation of both rowdy and rascal in the right thinking members of the society. Correct? So, and it refer clearly to rowdy and also rascal. And it had been published on air via Instagram. So the facts in issue is actually Instagram. What about relevant facts? This document itself, if you look clearly, is the photograph, a photocopy of the agreement. The agreement is actually pertaining to the loan. So you have to ask yourself, is it a relevant piece of the evidence? You get me so far? We are not suing people for breach of contract, not breach of loan agreement. We are suing him for defamation. So what is the relationship of the defamation and also the defamation itself? What is the relationship of this agreement? Okay, I will argue as such, in order for me to clear this relevancy chapter, you see, I will say that because sometimes when the defamation, yes, you make a defamation against one individual, but there are defenses available for the defendants. For example, fair comment, justification, or truth. The truth itself, sometimes you may not, especially not the truth itself, the justification part, sometimes you cannot cover the whole truth. If let's say the statement itself is partially true, then the court will accept this defamation post itself as a justification. You said it for a valid reason. So this is where the agreement will have come into play. The agreement is to show that the loan is premature. So whatever said by Richmond was actually not true at all. It's baseless from the beginning. So what I'll use is I will use section 9. Bear in mind, section 9 is a very wide like a sea, as wide as a sea punya a section in Evidence Act. So this one is to corroborate facts in issue and relevant fact, like I've told you, and this will be admissible. Okay, that one will afford you 1 mark here lah, properly. Okay, can understand so far? Relevancy have to be fulfilled first. Okay, then you talk about admissibility. Admissibility is something to do with the document itself already, with the nature of that document. Looking at the photocopy agreement, this is a photostat version. And the agreement, let's say now we have e-signature lah. Of course, e-document is actually acceptable by court, but if it is a traditional type of loan agreement, the best evidence rule normally require the original documents, the primary document to be produced. Okay, so this is the basic principle of law. Okay, so the photocopy is a secondary document, section 63. Okay, so not all the time the court will accept secondary document. Photostat document lost originality, lost authenticity. So that's why sometimes the court will reject it and only mark it as ID. If it is marked as ID or identity rather than exhibit in court, so the court will give very little or even eventually no value at all, to this particular evidence. So the case itself will be in trouble. All right. Okay. So now actually, how you admit this as photostat agreement? You have to rely your section 65 subrule 1 subrule A, where it states that the original version is in possession or power of the party against whom the document is to be proved. That means to say it's actually with Richmond's solicitor. But before you can do that, before you can do this as of right, you have to do your due diligence. Otherwise, things will be very simple in the court. There must be certain threshold. Okay. The best evidence say that primary evidence must be tendered. If you don't have, you want the court to accept secondary evidence, bear in mind, there will be some criteria, requirement for you to fulfill. One of it is that you must give notice to produce under section 66 to the opponent first. So you must write into Richmond solicitor. Okay, this is like a form lah, and then you e-file it and serve it to the Richmond solicitor. If Richmond solicitor sit on it, did not produce the original at trial, then photocopy of this document can be admitted. Otherwise, it is not as of right. Bear in mind, okay? Bear in mind, So this is your gateway, section 65 1A and section 66. Okay. It is only when Richmond fails to produce this document at trial, the photocopy of the document becomes admissible in accordance to the section 65 1A read together with section 63. Okay? But having said so, Rowdy is the one that signed the document with Richmond. They still need to prove whether there is a true execution or not. That means to say, yes, this agreement has been accepted by the court, but however, there is no in-mark, there's no pen dawat pen dalam photostat, document yang photostat ini. Jadi, what you need to prove is that you need to prove the signature is done by Richmond and then it's also done by Rowdy, So this is how difficult would it be. Okay? Can anyone follow me for question A? Can you all understand what I'm trying to say here? Okay, good. Okay, second question is about the cafe business account. Okay, make your mind like a litigator. Okay, assuming you are bringing this case to the court. Okay, first thing first, you have to consider what you want to achieve with this business account thingy. Okay, what you want to do with this business account. Okay. Somebody asked me, do we need to produce signature? No, no, no. You answer the question. That one is stretching the question a bit too much. You don't have to answer section 47. That one is concerning to expert and non-expert signature opinion. That one no need first. Okay. So first thing first, you have to consider the nature of the business account. What is it for? Is it a relevant piece of evidence or not? So, because this is pertaining to a defamation suit, okay, so what is the damages, head of damages, damages, okay, head of damages that could be awarded by the court is special damages, general damages, and aggravated damages. Here, the purpose of the account is to show what? To show damage, correct? Kerugian yang dialami oleh plaintiff. So this fit in section 12. So therefore, this is a piece of relevant evidence and the judge will have to admit it pursuant to section 136 of Evidence Act. Okay, very important. So you argue like that. Relevancy already achieved. But like I've told you, if you have satisfied the relevancy element, next step you have to move to whether this is admissible by court or not, which is a question of law. You see, the account prepared by who? By Abu, correct? By right, for you to admit these accounts in the court, Abu need to come to the court and say that, okay, look, judge, I prepared the account by myself and I'm fully aware of all the information inside this account, the balance sheet of the account, the profit and loss chapter of the account is well prepared by me. So I'm fully aware of it. And I now submit to you as truth of the matter. But now it will be a documentary hearsay because Abu tak ada. Okay. Rowdy and Rascal, they are not the maker. So problem. So this is documentary hearsay because the maker is not coming to the court to testify. So what to do next? You have to find documentary hearsay exception. Okay, documentary hearsay exception that is commonly used for civil court. Civil case will be section 32(1)(b), which refers to statements that prepared in the ordinary course of business. Or the other one is section 73(a). Okay, very simple. It's only two only. Okay. But for you to actually admit this, because I told you already, this is documentary hearsay. And by right, the opponent has very right to object it. Okay, you have to also satisfy the criteria of this. Okay, section 32 and section 73(a) is not an automatically invoked section. It has to be satisfying the precedent conditions. That means to say, before you can use this section, you have to show that the maker is dying, is dead, unsound mind could not be traced. I have tried my best. I have WhatsApp him. I have telephoned him so many times, but he could not be found. So this is how. Okay, and the cost to actually ask him to come to court will be more than the amount of this suit. For example, I have to ask Abu to come back from London. I have to pay for his air ticket for about 10,000 ringgit. So the value is very high and it will be very taxing on part of Rowdy and Rascal. So this is practically impossible to do so. So this is part of the criteria that you have to fulfill. Okay, very simple. Section 73A and section 32 1B. This one you must argue. Okay. So this is the thing. And in order for you to score a bit more, the burden is actually for you to show why Abu cannot come to the court. Okay, very important. Can section 32 1B, if you want to argue a bit more, is that the weight itself. Whenever the court deals with hearsay, the court will be required to guard this evidence, not to overweight it. Because having said so, why is the rationale behind is that you see the maker is not coming to give testimony. This is like nobody can testify. Yes, no doubt it is already being admitted in this court, but the court can still balance the weight, whether this figure is correct or not, or this is a trick play by the plaintiff lawyer. We are not sure. So section 158 govern the section 32 as a whole. Section 32 punya hearsay weight, okay, documentary hearsay weight or whatever hearsay weight, and section 73A sub rule 6 governs the weight for document hearsay under section 73A. Can you all follow me up to this point? Okay, so you can see how I argue is like a real lawyer giving submission in court. I argue first relevancy, then I argue admissibility. After arguing admissibility based on the relevant section, okay, then I talk about the evaluation of probative value attached to this piece of evidence. So your mind, when you do the exam, should follow this style. You understand what I'm saying or not at this moment of time? Can you all follow? Okay, so I move to the next question. So each and every question regarding to evidence, number one, why is this evidence here? Why should he present to the court? Second, whether this is admissible or not. If it is admissible, it shouldn't be a hearsay. It should be a direct evidence, not passed by some other people. Okay. Number three, what is the weight attached to this particular evidence? Okay. And question C, we need to discuss whether Rowdy and Rascal bear the burdens of proof of Richmond's allegations that he's not the author of the video and that his Instagram account was hacked at the time of publication of video. Okay, so now we know that in any civil suit is a plaintiff versus defendant. Okay, plaintiff will bear the burden of proof of that particular cause of action. You see? Okay, the cause of action here is defamation. So plaintiff will need to prove all the elements of defamation plus damages that the plaintiff suffered. Okay, so this is the standard requirement. Along this case, okay. But now, okay, in order for us to prove defamation, we have to produce the Instagram post to the court, correct? That Instagram post itself, by all means, it is a digital agreement, a digital evidence, sorry. Okay, so this is something new in modern era. Okay, so it could be a snapshot or it could be a URL link. Okay, and now, okay, Rascal said that he didn't publish this Instagram because the account was hacked. This is very normal excuse given by the evidence by the defendant in case of a defamation case. But you must invoke this presumption. Okay. Section 114A is a presumption of publication. Okay. This is back in Najib, the Prime Minister Najib Razak's time, the 1MDB case punya mastermind, Razak's time, in which a lot of cyber trooper, you know what is cyber trooper? Those anonymous person that use fake account, use their own profile to publish defamatory statement about the government, about a politician. So that time, for you to actually sue a person for defamation, first you have to prove that the account belongs to him or was actually in custody or controlled by the person that published the content. So this create a lot of hardship, So presumption of publication had been enacted by the parliament that time. Okay. What does it mean by presumption here is presumption, it works like a magic. Okay. Presumption is a very creative invention of law. It's an invention of law. Okay. By right, the court cannot presume things. The court has to see real evidence. But somehow, like I said, it creates a lot of hardship and difficulty and also challenges. So what they do is when this presumption is invoked, okay, take for example, when we talk about section 114A, how to invoke this presumption is that to show the Instagram profile belongs to Richmond. Ini Richmond punya foto. The profile said that I'm a friendly loan punya user. A telephone number is this match with his identity, then this account automatically belong to Richmond. And whatever that had been published by this account will be deemed published by Richmond personally. Okay? Can you understand? For you to invoke a presumption, there will always be a basic facts. The basic facts must be the Instagram photo, phone number, personal data are matching Richmond identity. So after that, once this presumption is invoked, the evidential burden shift to Richmond to show that he is not the owner of this Instagram, which is very, very hard. Okay? You must remember, a burden of proof sometimes could have shift to the opposite side, especially when there are certain issues like the defendant or the accused want to say something that is only within his particular knowledge, or he want to assert the fact that the accused, the prosecution or the plaintiff cannot use his power to prove. Okay? So presumption is one of those of this kind. Okay, basic fact must be proved by Rowdy and Rascal. After that, whether this is hack or not, okay, are all particular facts. Okay, you have to use section 103 and 106 Evidence Act. So there is no reason for Richmond not knowing who is actually hacking or is in control of his own Instagram account. Okay? So in a very simple word, in a very simple word, when you have 114A presumption, then the evidential burden shift to the defendant. The defendant will need to prove to the court Instagram lost control. When? Is there any police report? Is there any particular person that have used your Instagram for other purpose? Is it really not belong to you? They use a fake photo created by AI. So you have to prove. Richmond have to prove. And the plaintiff are not required to prove any of it. So far, so good? So far, so good? Can you understand? So you must argue like a lawyer here lah. And this is normally what is required by the exam. Okay? So far so good or not? Do you have any problems when you want to discuss about presumption? Another famous question is presumption under DDA. DDA, Dangerous Drug Act. Okay. I give you one scenario is that, for example, if you have 3 kg of heroin. Okay, for example, now I'm teaching in my study room of my own house. Okay, there is a 3 kg heroin. Suddenly the narcotic teams of the police raid this house and found it in my storeroom. Okay, so the basic fact You see, the basic fact the police need to prove, the prosecution need to prove to the court in order to invoke Section 41DA, the trafficking punya presumption, is that the house is actually registered under my name. And then I am the only person alone in the house at the time where the drugs is found, and the kg itself, 3 kg, is more than personal consumption. I cannot finish this 3 kg of heroin myself. I cannot be so addicted and consume 3 kg per day. So they have invoked these basic facts, then the court will automatically presume, oh, this Dr. Chi is a businessman, is a drug trafficker selling heroin. Okay, can understand what I'm trying to say? Same thing. Same thing is going to happen with section 114A. Okay, take for example, now I stop, I mute my video. Okay, now you are seeing Chris and partner, advocate and solicitors. So whatever defamatory statement that I'm going to make against somebody later on, okay, will be deemed published by Chris and partners, You get me? Okay, so this is section 114A of Evidence Act. Okay, basic facts, the plaintiff or the prosecution need to establish. Subsequently, it shifts to the defendant or the accused to disprove it. So this is rebuttable presumption by law. Can you understand? Or you are not listening? Are you able to follow my lecture so far? Okay, this we have a few. Okay, good. Okay, we move to second question. Second question is okay. See, we have a couple here named Caroline and John. They were married back in 2005. You see, 2005. Okay. So 2010, Caroline discovered John is cheating lah. Is cheating with Hannah, his yoga instructor. But subsequently, this matter settled. Caroline actually generously forgave John and then opt to reconcile the marriage with him. Okay. However, 2023, you see, Caroline's suspicion were rekindled when John began to develop another relationship with Mel. So this one is second case already, though. So with Hannah is the first one. But the first one, Caroline did not do anything. Okay. So having realized that the mistake can only be committed by man one time in his own life, so this time Caroline didn't give in. Caroline chose to divorce. Okay. So this is a matrimonial case. You see, matrimonial case. Okay. So the plaintiff competition history, competition history is apa nama? Caroline. Normally in adultery suit, is quite dramatic. So we'll name the competition Swami as John, plus the adulterer Mel as the respondent. Okay, as the ground for divorce lah. Okay. So this will be a single petition for divorce under Section 54, Law Reform Marriage and Divorce Act. Okay. But now the question asked you is that police report lodged by Caroline in 2020 25. You see, 2025. Okay. Okay, you have to read the question carefully. The relationship is discovered when? 2022. Now you commence an action. Okay, we take the action to be on the date of your supplementary paper, which is on 2025. Okay, suddenly you have one police report back in 2025, same date and same year of the year of your petition, the divorce petition. Okay, so they ask you what will be the evidential issues arise if this sort of scenario happen. Okay, police report itself, number one, again, we go back to the very basic, very basic. What is this police report meant for? What is the purpose to come to the court? Why you need a police report to divorce? Okay, because now you want to do a single petition for divorce. And the reason behind the separation is because of adultery. Adultery, you have to prove infidelity, not loyal to the opposing partner, to your spouse. Infidelity, usually you need to provide WhatsApp message. If you have some hidden camera, that will be absolutely fantastic because it will show the act of adultery. Or you have some intimate circumstantial evidence, like you found some, sex toy, condom, all that, or even some underwear, undergarments of the lady found in your room. These are the things that will support the case. But the police report here is merely refer to first information report or a police statement pursuant to section 107 of CPC. This is not itself a substantive evidence. You do not need to have a police report to establish adultery. You get me? Okay? You do need that. And you cannot prove adultery by a police report because the police report will be made by Caroline. And Caroline is the one that asserted the adultery did indeed happen. Okay? But having said so, you must also consider this part, corroboration. Corroboration is one of the very important element in evidential ruling, in which to say sometimes the whole truth itself is very cloudy. You need to support with other evidence, Like I said, adultery. In this case, most of the time you don't have a hidden camera, but you have WhatsApp messages. But that is still not enough to establish adultery because you are just making friends with all this social media and all that. Okay, but what if you have more evidence, okay, to support this adultery? For example, you have eyewitness seeing both party went to the hotel on that particular time. Okay, so you have a booking.com punya the booking.com punya receipt to show that both of them went, is booked under the lady name, and then you have some photograph that will corroborate or what we use in layman terms support your case. Okay, so this police report how does it operate usually is to corroborate the maker's latest testimony in the court. As simple as that. To say that, look, this is not an afterthought. This is true. I make the police report because police report, you cannot make a false police report. Otherwise, you'll be penalized. You'll be charged for making a false report. Okay? And to say that this lodging police report is a conduct of the event, the adultery event. But somehow rather, your eyes must be very sharp. This police report is made in 2025, But the year to discover of the adultery event is 2022. So what is the evidential issue is that, is this evidence self-serving in nature? Is it created? Is it purposely made when you have a court proceeding? If you have a matrimonial proceeding, that means to say, this evidence, you do it for the purpose of proceeding, for the purpose to get ready for trial as one of the bullet in the trial. So I will say this probably is an afterthought. Okay, so this will be the argument that you wanted to say. Because if, let's say, for example, I give you another hypothesis, this is made on the day 2022. Okay, this will be carry much weight, because it is done immediately or even after a few days still okay. So that means to say, when the court hear this matter in 2025 or 2026, you have a reference. This is a truthful testimony. So therefore, whatever I hear from Caroline during the trial now, it is supported by police report. Okay? But police report, for adultery case, it is not substantive. In matrimonial proceeding, the police report is particularly helpful in domestic violence case to show those unbearable and intolerable behaviors of your spouse. The spouse keep on slapping you, pinch you, hit you, punch you with a fist and all that. Okay, that one will carry weight. But here, no much weight. I will submit no much weight. Okay? As simple as that. Okay. So B, endearing WhatsApp message exchanges between John and Mel between 2025 and 22 and 2025. Okay. So again, you have to consider what is it? Okay. What is it? It is a form of digital document. Okay. And so this one is admissible. Section 90A. Okay. Section 90A, all you need to do is like this. You have two choices. Either you tender a certificate under Section 90A, Subrule 2, or the person that know the computer means the WhatsApp, the phone is in good working condition. Come to the court to say that, okay, this is a digital document. As simple as that. Okay? As simple as that. Then subsequently, you have to argue whether this is relevant or not. Okay. So like I've told you, adultery sometimes is best to prove with hidden camera or intimate photos, but often than not, you will not have it. So you can do by other circumstantial evidence. Circumstantial evidence refer to those indirect evidence. So WhatsApp message that is calling people honey, my dear, all that will establish the abnormal relationship. So that particular thing is actually relevant. Okay, but you are not quite done yet with WhatsApp messages. Okay, WhatsApp messages also were required for you to establish the identity. In a very brief nature, you have to show that, okay, this number, this profile, WhatsApp profile actually belong to John, and this one is actually Mel's photo, in order for you to invoke presumption. So this is the issues, the evidentiary issues surrounding this piece of evidence, And 2022 until 2025, because they are still in a matrimonial relationship, John and Caroline. So by right, to keep the harmony of our society, a family is very important. That's why it's very easy to get married, but it's not easy at all, to go to court and seek for a divorce, because matrimonial harmony is important for the stability of the country. Okay, by right, as a third party, you cannot simply interfere. Okay, the relationship of a husband or wife, and you could be sued for adultery. Adultery, the maximum damage you have to pay now is 150K. Okay, if you read judgment lah. Okay, so this is how so in conclusion, WhatsApp message could be admissible, and this is a form of computer generated document, and it is relevant. Okay, to show adulterous relationship. Are you able to follow me so far? Can follow me, okay? So this is the style that you should make out the argument. Okay. Now we move to C. Okay. C is evidence relating to John's prior affair with Hannah. Okay. Prior affair with Hannah, this one is long forgiven, isn't it? It has been forgiven. But now Caroline does not plan to forgo it. Okay, so she wants to bring it to the court, whether this one is okay or not. So first you have to identify in order for you to establish this sort of past affair, the prior affair, what is the purpose? Okay, number one is to show similar fact evidence, or similar facts evidence is to show pattern. Sorry, this one a bit typo. And past character, he's a playboy. John is a playboy. Okay, as simple as that. Okay, so what actually happened here is that in any proceeding, we are trial of the facts. The judge is only concerning with the fact of this current case. So be good or bad, this discussion itself, the whole trial of divorce proceeding must only evolve between John and Mel only. Other evidence by right should be rejected by the court. Okay. For example, similar facts evidence okay, is something to do with the pattern, the propensity of a person to commit similar thing. Let's say, for example, okay, Ali is a principal of the school, headmaster of the school, and he himself is a pedophile. He loves kids, he loves to molest kids. Okay, back in 21, he molested two. 23, molest again, 3. So 2025, he got caught lah. Somebody reported him. So these two here is similar fact evidence. Okay. All the time, how to show is that he will call these kids to his headmaster room, and then he will ask them to take off their what we call the pants lah. Okay, something to that meaning. And in this particular 2025 case, he did the same. Okay. So the governing principle is that the court can only discuss 2025 punya molestation case. The previous one, if the court wanted to admit, it must exercise caution. Very high caution. Okay, very high caution is based on the Bodman test. Bodman test said that if the evidence has more probative value, it's very convincing. This similar fact evidence is very convincing. Okay. Outweigh the prejudicial effect. Any similar fact evidence will negatively detrimental to the accused. Confirm. Otherwise, it will not be used against it because prosecution will have a good case already, isn't it? So the value of this evidence, the court must be very convinced, hey, I need to use this evidence because the prejudice, the bias caused against the accused is so low until I can eliminate it, Okay? But we come back to here. This one is a civil case. This is pertaining to a divorce proceeding. So, divorce proceeding, usually, it is not admissible. It is not admissible. Okay? Bear in mind, similar fact evidence is not admissible in civil case because the prejudicial effect is very high in here. Okay? Second thing is you can also use this character evidence because this past behavior, it is not just to show the similar fact itself. You have adultery with woman. Okay, last time your yoga instructor also like that. So actually, the second purpose is to hammer the credibility of John to make him look like a playboy. Understood? Make him look very bad before the judge Okay, so that will be a character evidence. But based in mind, character evidence you can only use to show general reputation. And general disposition. Reputation is something that given by the society. Take for example, okay, Dr. Chi, me is a very reputable lawyer. I cannot say that I'm a very well reputation. It must be conveyed by somebody among you. I cannot self-label as a person with good standing in the society. And this reputation itself must be a general version. I cannot claim myself to be a reputable lawyer for conducting a pro bono class. As simple as that. I must cover a lot of aspects. I must do charity, for example. I must help to the homeless cat or dog, I must also do some pro bono case in my advocacy conduct. I must be a good husband, etc. So this is general reputation. It must not be judged by a specific act itself. Okay? General disposition. Disposition means inside your heart, inner value. Whether I have a dark side of myself, whether I'm a genuinely a true kind person, that one you can't tell for sure. Only I can tell. So this is general disposition. So to say the person is having a good character or bad character itself is rather irrelevant. In both civil and criminal case, it will be not relevant at all because we do need to know whether you are a good person or not in order to convict you. We don't need to know whether you are a good doctor or a good lawyer to find you to be negligent in this case. We are very concerned about this case only. You get me? So civil case, cite the right section, section 52 and 55. Usually, we need character evidence in civil case is what case, defamation case. Defamation case, you will need um to prove damage. If let's say I am a badly I'm a person with bad standing in the society. Everybody knows that I'm a con lawyer, for example. If let's say you post a defamatory post online, saying that this Chris and partner, this lawyer cannot every time he'll lie and then all that. Okay, no doubt this is defamation, but subsequently the value of the damage will not be high, because I cannot show good character in court. But whereas if I'm the top 100 firm, I'm the best lawyer in Malaysia, all this good reputation around me, and then I show my portfolio, I teach pro bono, I donate in charity, I'm the panel for this what we call NGO. This reputation will give you a very high award in defamation case. Okay? And therefore, the evidence of Hana is inadmissible, regardless the court wanted to treat it as similar fact evidence or character evidence. It would not help at all, okay, to establish the cause of action here. So far, are we good? I hope you can understand. This one is very, very important for your practice later. Okay. It may not be so important for exam because exam will not cover so much, but for you to excel in career, you must know the general principle attached to that law. Then this is for you to pass to be a litigator, general litigator. For you to be a mediocre litigator, you must know what is the exception to that general principle. And for you to be the excellent lawyer, the top lawyer, you have to know the exception to that exception. Okay, so you are the smartest of the smart. Okay? Otherwise, you cannot survive in litigation world. It's a pool of shark. Okay? Next question. I think we will finish 4 questions because time is running out. And then we'll continue with other days. Hey, when is your exam, by the way? I didn't check. When is your exam? 20 July, or still long time to go lah. You still have time, no problem. Okay. Now start doing question, please. Okay. Uh, this question, I personally think that this is a must-do question. It's very easy. So long you know the way how to answer it, then you can score. It's basically to talk about the standard and burden of proof, which you shouldn't miss when you are doing revision. In fact, not to say you should not miss, you must be exceptionally well in this chapter. Okay? Very important. So what happened here is Brandy had discovered that his land was transferred to one Cluedo by power of attorney. Okay, so Brandy subsequently claimed that when the time he had a heart attack and fell sick, so he executed this power of attorney. That is a form of surat kuasa to give my right to sign documents before the land office, before the advocate and solicitor, the full power to dispose this particular land to one apa nama Gerardo. Okay, and after Brandy had recovered, he asked Gerardo to revoke this power of attorney, to cancel this power of the attorney. But without his knowing, what Gerardo misused is that he entered into a sell and purchase agreement to sell the land to Akma. Okay. Then after that, Akma sell the land to Halib. Okay, you see, you see here, the land actually owned by Brandy. Brandy put Gerardo vested the power through PA. Okay, sell the land to Akma. Then Akma sell to Halib. So this one has caught by the issue of, especially Halim here, there's a deferred indefeasibility here. Okay. Anyhow, Brandy, if to sue Halim, he cannot get back the land already because he will be deemed as a second purchaser. Okay, defer indefeasibility pursuant to section 340 National Land Code will apply here. Okay, get me? So now what happened is that Gerardo had one criminal case, criminal breach of trust, CBT, criminal case. That one is police charge him. So he dishonestly used his power of attorney dishonestly and sell the land, okay, and use the proceed of the land to invest in pyramid scheme. So Brandy separately also commenced a legal action. So this one is like this. Now you have two. PP against Gerardo, CBT. This is criminal. And part of that, you have Brandy versus Akma and Halim. So this one is civil lawsuit to recover the damage. Okay, now you are asked to discuss the burden and standard of proof of the prosecution to establish the charge against Gerardo. This sort of question, when it comes to you, is a lucky draw strike you have to do. Okay, start with the general principle. The legal principle is DPP against Wilmington, or you can cite Malaysia case, MUD against PP. The legal burden lies on the prosecution throughout the case. Okay, section 101 and section 102. Okay, and the standard is proof beyond reasonable doubt. Okay, that one very important. Okay, So proof beyond reasonable doubt means you have to prove with a good evidence, but not beyond shadow of doubt. Later, I have some photographic info to show you. Okay. So basically, at the close of this prosecution case, because this is a PP against apa nama Herando, so at the close of prosecution case, the prosecution must establish a prima facie case on maximum evaluation of its evidence. Okay, so this one you can use section 173H or section 180 or 182A CPC if it is high court case lah. Okay, depends on the case, but the principle is there. Okay, so to prove, and this is important, this statement itself, you shouldn't miss in examination because you are asked to you are not regurgitate the sample question, template question. You have to apply how to prove CPT. So prosecution must prove Gerardo had been entrusted with the one land, okay, which is the proper power of attorney plus minus the money collected if the property had been sold. And subsequently, he dishonestly misappropriated or used it. Okay, for example, spending in the pyramid scheme in violation of that particular trust. Because you want to say breach of trust, there must be some form of trust here. And the trust had been breached, violated. And criminal element is the mens rea, dishonesty or fraudulent intent. Get me? So these are the ingredients that the prosecution DPP need to prove. Okay. So like this, you write like this, then you'll score a bit better. If you write just you argue about the DPP against Wilmington, Mart against PP, you only score a bit of mark. Okay, you cannot do like that. You have to apply, as in you are the PP, what you need to do in this case. Okay, faham tak? Can understand? So far, can understand me? Okay. So this is B question. The burden of proof. Remember, there's also the burden and standard of proof of Gerardo to discharge his defense. Okay. For you to say that, okay, DPP would have established dishonesty. The trust is actually formed between the party, and then there's a breach. Okay. But however, you can still defend one, isn't it? The defense by how? I got the trust punya consent. Okay, I got the consent or acquiescence from Brandy. So this is how you discharge your criminal liability. Now, what Gerardo needs to do? Okay, accuser does not need to go up to the beyond reasonable doubt standard. He only need to go with balance of probability standard. Okay, he need to cast a doubt. And that doubt itself is not just come from air. He must prove how he got this consent. So general rule is that he does not need to bear any legal burden to prove his guilt, to disprove his guilt, sorry. But let's say if he's to raise such a defense, and that defense is a special one, only he know, DPP will not have known it. So this one you have to rely on section 105. Okay? He has to prove how he got the consent. For example, is there any WhatsApp message between him and Brandy that he sold the land and that money is to invest in pyramid scheme? Something to that effect, So this is consent already. Or is there any written approval by Brandy that he can sell the land to any party that he wants? So that one, he has to raise it. He has to provide evidence to the court. Okay. Likewise here, you can use section 106 because it is within his knowledge. Okay. That one nobody know. Only he know. Okay. But his burden is only evidential burden. It's not legal burden. Legal burden and evidential burden is different. DPP, legal burden. Accused, evidential burden. Evidential burdens only means you have to raise the WhatsApp message, the written consent that I've told you. That's it. So this is not a very strict legal requirement as compared to DPP. And then this is BOP, balance of probability. Okay? So you have to argue according to the facts. Don't just cite some principle, then that's it. Cannot. You will not score. So the third question, Bara, is C. Discuss the standard and also burden of proof on part of burden against Akmal and Halim. Okay. So this one is a civil case. Civil case. So in civil case, the legal burden is on plaintiff. He who asserts must prove. Okay, he want to claim the land transfer, the SPA is void for the fraud, issue. Okay, so the standard involved here is balance of probabilities. Okay, so subsequently, because the word I highlight very big here is fraudulently transfer. So the landmark and classic case you must cite is this one. Sinaya and Sons against Damai Setia. This is a classic case for fraud. Last time, for you to say this is a fraud, this is a serious allegation in civil proceeding. Okay, that's why if you read close enough, Order 18, Rule 8, Rules of Court, you have to particularize the fraud. You cannot claim just one sentence. The land has been transferred fraudulently to Akmal and Halim. If the opponent counsel is very smart, you will be doomed. Your statement of claim will be defeated by lack of particular. Okay, very serious. Okay, so last time it is a serious allegation, and the court think it may not just, the standard is higher than this, balance of probability. It will be near criminal threshold. But after this landmark case, Sinaya and Sons and Damai Setia, and here, after the date of the decision, any ruling of the case, after this date, will be balance of probability for any fraud. Okay? For any fraud. This is also called doctrine of prospective ruling. So any day of judgment decided after the Sinaya and Sons case will be all the fraud, civil fraud will be proof on balance of probabilities basis. Okay, this is the only standard of proof across civil proceeding now. Okay, very important. How you want to use the law based on the fact, you can only say this. The knowledge, okay, the knowledge Halim and Akma knew about Brandy's medical condition, support and also corroborate lah. They might be involved in conspiracy. Okay, they may not involve in the fraud directly, because having said so, you must understand how the law works is that who cheat Brandy? Gerardo. Correct? Gerardo is the liar, is the scammer. Akma and Halim involved in a fraud, in this fraud. Unfortunately or fortunately, I don't know. Okay, involved. He's just a party. So, is it really valid? Normal circumstances based on reality quite hard. The notice that to show that Halim and Brandy's know that the medical condition itself will not support substantively on the civil fraud cause of action. Okay, but you can say that they may not fit into the criteria of bona fide purchaser without notice. Okay, they are not equity darling. Because for you to seek bona fide things, you must come to court with clean hand. You must be totally innocent. Okay, like a Snow White type of version of people. You cannot be tainted. Your hand must not be dirty. So now they will be a bit dirty lah, Akma and Halim. Okay, so this is still relevant. But the legal burden will still lies on the plaintiff. Evidential burden will shift to Akma or Halim to show they are bona fide purchaser for value. Okay, very simple. I have a few diagram to show what is the meaning of beyond reasonable doubt. In practice, our clients sometimes, especially the accused, okay, in criminal case, they'll act smart. Okay, so how you explain beyond reasonable doubt and also beyond the shadow of a doubt? This is Lord Denning judgment. You see, to establish beyond reasonable doubt, the juries, UK court, they have juries, that means the 12 laymen, they must be convinced that the evidence is very strong, okay, and convincing up to the point that jury is sure of guilt. Okay, any doubt remains is only remote and imaginary and not reasonable possible. Okay, it's just like the difference here. For example, you take a photo, you can see this man is standing with a car, isn't it? That photo. But you can see there's some shadow of the car and shadow of the man. So, but having said so, this picture itself has no how to say, has gone into the level of beyond reasonable doubt to show that, for example, I am standing beside the car. But whereas beyond the shadow of doubt here is a lot of imaginary question that is full of theoretical, fanciful one. For example, what if it's not there? What if it's somebody else? What if there is another possibility or another explanation? So this is beyond the shadow of the doubt. Okay. In legal practice, we are not seeking for perfection. To convict a person, we only need to go beyond reasonable doubt, not beyond the shadow of the doubt. Remember that, huh? Okay. So the version that next time your client will ask you, if it's not me, it's not other people, will not stand in the court, okay. So whereby on balance of probability is easier, more than 51% likely on the other side, then you win the case. Okay, because um this timbang tara will tilt to your side. So this is balance of probability. And second thing you must know is, apart from 101, 102, he who alleged must prove, you must also know 103 particular fact, 104. Okay, usually this apply to section 32, 73A, the condition precedent. Okay, this one, 105, special defense under penal code. For example, you want to allege you are having insanity at the time of commitment of murder, or you want to allege self-defense. This is one of the defense allowed by penal code. So this one you have to use section 105. 106 is apa nama, within the knowledge of the party. Then the evidential burden will shift to you. Okay, so this one I prepare, later I send to the group. You can revise it lah. Ayo. Okay, last question. Thank God. Okay, Tom had been charged with murder of Keith by fatally stabbing him. So this 302 lah, murder. Okay. So now prosecution's key witness is Tom's wife, Anna, and also neighbors, 18 years old. 18 years old is not a minor. Please remember that. Very important, because her evidence act sometimes take into consideration of minor and unsound person that suffer from infirmity. We have also evidence of Children's Act, ECWA, okay, and also some sexual offense against children. If let's say they are less than 18, sometimes they are the General Evidence Act itself does not govern their conduct in the court. This one you have to roughly remember. Okay. So what happened next? Okay, so Tom is known to visit his priest regularly to confess lah. Okay, so he's quite a holy moly person lah. On top of that, he's a murderer. So Anna is expected to testify shortly after the time of alleged offense. She saw Tom washing hands, which were stained with blood. Okay. And subsequently, Tom visited his doctor for treatment. So Maxine, the neighbor daughter, also expected to give evidence, having allegedly seen Tom running back to the house with a knife stained with knife. Okay. However, Maxine is frightened and reluctant to testify in court. So you have to advise the evidential issues. Okay, so you have to be a bit smart. What it meant by evidential issue arising if the prosecution wanted to call the witness. Okay. So now, question A. Anna to testify as what he had seen. Okay. We go back to First issue, we must know who is Anna. Okay, he's the wife. Okay, like I have told you all early in question 1 or 2, I forgot. Okay, matrimonial relationship is very important for the stability of a country. And apart from being a good wife who can take care of the household and also the kid, the wife is also expected to keep the secret of the husband. Like my wife cannot be compelled to testify that I told my wife, for example, I swindled 1 million ringgit from my client's account. I cheated my client. I told my wife because I can't sleep at night. So she's the next person I sleep with. I told her, hey, you know that day I did a mistake. I have to confess to you. I cheated my client. So my wife cannot be compelled to go to court to give such testimony, even though she hear it. You get me? Because this is marital communications privilege. Okay? Pursuant to Section 120 Subrule 2 Evidence Act and Section 122 Evidence Act. Okay. Without my written consent, without me waiving that particular privilege, such information cannot be raised in the court to go against me. Okay? To protect marital relationship. But however, you have to look closely at the gist of the question. Is Anna going to say something Tom told her? If you look at the question carefully, it's not, He saw the act, okay? The action or the conduct of Tom washing hand, and the hand got blood. That's it, So this thing itself, okay, is it a communication? Okay, it is not. It is a form of conduct. All right? So this is not a privileged information. You can understand me, okay? Whereby you have to take note of one case here. Paudas Arumugam against PP. If let's say for example, okay, if the conduct or the act itself is inextricable, or what we call as in layman term, cannot be separated from the communication, this will be privileged. For example, if I do like that, point my finger when I was talking, so my act here is part of the communication, to show that I point to that person. Okay? That part, even though the finger pointing would be a conduct, but it is not able to separate from the main communication, then this will be deemed as part of the communication and will be protected under Section 122, marital communication privilege. That is the exception to the exception. You get me? Or am I confusing you? But having relate to the fact, it is not that difficult. Tom washing hand, the hand got blood itself is a mere conduct only. So this thing not privileged. And after you have decided this communication itself is not a privilege, then she is competent person. She's compelled to give testimony of that particular conduct. Next is that you must also decide what is the purpose, what is the relevancy of Anna's testimony. So that one is post-offense or subsequent conduct pursuant to Section 8 of Evidence Act. So this testimony itself is complete. Okay, it is admissible version. Okay, so you have to argue your answer like that. Okay. Next, you are asked to consider Maxine. Okay, Maxine here is not a minor. So the evidence, the ECWA lah, does not apply. Okay, but now she's a bit challenged with dyslexia and speech impediment. That means he has medically known as probably some speech difficulty, staccato speech, like I can not this sort of dyslexia um um illness, it's a form of illness. Okay, and some more, the the text or the facts given to you is that she's very scared. She refused and reluctant to give. Now, whether we can subpoena her to the court or not, if let's say the witness refused to cooperate. Okay, Section 118 said that all the person are a competent witness, provided they understand the question and they know the reason behind every questions they give. Okay? Unless they are subjected to tender age, extreme old age, disease, or unsound mind. Okay? So the competency here is entirely based on the capacity to understand the question put forward by the prosecution to Maxine. It is not based on whether I'm 70 years old or I'm 18 years old. There's a difference. No. It is also not subject to the dyslexia illness. Okay, you get me? Having considered this is a speech problem, you may also want to bring in Section 119 Evidence Act. As a matter of fact here, if you know, evidence can exist in the court in two forms. One is oral evidence. You call witness to give testimony. So you hear the judge hear directly from them. Oral evidence. And sometimes we have, and a lot of time, we have documentary evidence, photography, agreements, invoices, etc. Okay. When a dumb witness come, for example, he cannot speak at all. The court will deem the evidence of finger pointing or point the words on that as oral evidence. Okay? Please understand that. Okay, even she's dumb, she can still give writing or signage, okay, which will be deemed as oral evidence here. Okay, so being dyslexia and having speech impediment does not exclude Maxine to be incompetent. So normally how the judge will do is, if let's say this person appears to be, we don't want to say that she's disabled, but we want to label her as a bit special witness, the judge will ask her, okay, do you know your name? Can you tell me your name slowly? Okay, what is your address? Do you know where are you now? To test her understanding. If she can understand the question and answer it well, then no problem. The court will automatically ask her to give evidence. Okay. And second part is that you have to consider her fear and reluctance. Don't leave it out. Don't say that, oh, she's a speech and all that is fine. Then you forgot to mention about her fear and reluctance. Okay, that one is actually not a grounds of incompetence. Okay, you cannot refuse to come to court. The prosecution will actually issue a subpoena to compel you to attend to the court. Okay, and since she's 18 also, she'll be treated like a adult witness. So far so good. I hope you are good. Okay, now we have the priest whom Tom visited him to confess his wrongdoing. A bit of marks here lah. Okay, so now you have to know uh, the person that comes is the priest. Okay, so priest whether privilege is applied or not. Okay, then the second thing is about confession. Okay, confession something that incriminating the accused. Okay, you have to understand in Western country there is something called canon law. You can confess to any officer of the church or religious body that, God, I'm sinful person. Why I'm sinful? Because I just killed my wife, and I seek for the God forgiveness so that I can go to heaven, something like that. But in Malaysia, this clergy privilege under canon law is not applicable in Malaysia. So there's no privilege at all, apply to the priest. So you have to say that. And second part of your argument, you have to say that the priest is not is just a private person. He's not someone with authority. He's not like police who held the murderer in custody. So this is a form of confession which is relevant under section 17 to 21. Okay, so since there is no clergy privilege, the priest competent and compellable under section 118, and the information itself, the confession, is also not privileged and relevant. So therefore, he can give that evidence in the court. Okay, the last question here is also very simple. The doctor that treat Tom for his bleeding hand. Okay, this question I think is the extension of the privilege question. But for you to make a little bit of distinction, you have to say MMC, Malaysian Medical Council, actually provide guidelines for doctor not to disclose the private and confidential information of the patient. But however, this guidelines itself remains to be a guideline. It is not binding to the court of law. All right? And a doctor itself is a competent and compellable witness under section 118, that one no doubt. Okay. And this piece of information is relevant under section 8 to show subsequent conduct. Probably during the fight, the knife would have accidentally cut Tom also. So this is a piece of relevant evidence. So the doctor can come to court and give such testimony. All right. Wow. Okay. As simple as that. Are we clear at this moment? Are we all good to go? Can you all understand what I'm saying so far? Okay. Set your mind clear. Every evidence R, relevancy, A, admissibility, W, weight. Okay, privilege is about the admissibility itself. Okay, even though let's say the marital communication, let's say Tom is to admit to Anna that she killed one person. Yes, this is relevant under confession, isn't it? But because it is so privileged, it will not be admissible, you know. So you have to pass one, two, three steps. So every of the question, think logically with raw formula. Okay? This is what the our us lah, the practitioner will do also. If you fail to consider all this and you do not become so smart in court, you'll have a lot of problems, trust me. All right. Is there any other question that you feel like wanted me to address to you by this session?